microphone down just a little bit so we can be sure we hear you.
Sure, thank you.
That'll do it. Thank you.
Let me just get situated for just a moment.
Sure.
Well, thank you it's an honor to be here and to be able to make it from Chattanooga, Tennessee, to the great city of Knoxville. Basically, the reason I brought this to the Court of Appeals here today, there's just, to keep it simple, just genuine issues of material fact, disputing the plaintiff's case for an unfortunate, well, the plaintiff Tripcap Cross Creek. There's just no evidence suggesting that they were able to lawfully borrow us from living at the apartments that we were leasing from them. There was a tenure that they submitted without due timing that almost disbarred us from being able to live happily in our home. They unfortunately had breached their rental agreement under their lease, as well as Tennessee statute, Tennessee code, the Uniform Residential Landlord and Tenant Act, stated in Tennessee code. So that's what we're asking here for, an overturn of judgment to be able to favor us in our case. The simple codes that they had unfortunately breached, one of them being the implied warranty of habitability, which is Tennessee Code Statute 66-28-304. Basically, it's the tenant's obligation to pay rent and the landlord's obligation to maintain safe, sanitary, and fit premises depend on each other. So if the landlord were to break his obligations to keep the premises in a reasonable condition, the tenant does not have to pay all of his rent until the landlord makes the necessary repairs to the home. It furthermore states that any damages may be recovered by the tenant to obtain injunctive relief and recover reasonable attorney fees for any non-compliance with the landlord with the rental agreement that was signed, or in any section of the chapter based on any notice given to them in 14 days in advance that there was some sort of unfit or unsanitary premise in the home. Such laws were in effect, and unfortunately Tripcap was unable to keep their word based on the lease. More notably, in the lease agreement, they're on page 3 under paragraph 23, states that we would actually be able to terminate our lease with them if they were unable to keep their word here on their lease. And this is something that's been submitted to the court, both in sessions, general sessions, as well as the appeal court here. Their lease contract states on paragraph 23, unless you're entitled to terminate your tenancy under the paragraphs number 10 special provisions, which would be the portion where they had unfortunately terminated, or any other applicable law, you won't be released from this lease contract for any reason, included but not limited to voluntary or involuntary school withdrawals, transfers, job transfers, marriage, separation, divorce, reconciliation, loss of co-residence, loss of employment, bad health, or death. Under the special provisions under paragraph 10, based on that clause, they unfortunately were unable to keep alarm systems monitorings up to date, as well as pest control, and keep the home safe and compatible for us to be able to live in a safe and fit home. Unfortunately, they're, again, something that's been submitted to the court, their fire alarms were first installed and set to expire 2008 of June 25. And we're not up to date to the code and statute of the Fire Protection Association, both the National Fire Protection Association, the NFPA, and the state fire marshal offices for fire safety, keeping workable fire alarms that are within 10 years of age. They were given notice that the fire alarms were not working, as in not properly working, as well as they weren't able to help out with the issue until way after the 14 days, which would have been in November. They were given also a heads up about issues with pest control. We were having a bunch of ants and roaches invading the home, and they were unable to help with that issue as well. And so way after we had already, until after November again, when they were unable to help out with that as well. They had also been alerted that their security system, which is under the Special Provisions Clause, was not activated as well. And they were unable to keep our security at home safe, making it harder for us to be able to find peace. And it also went against what their lease had originally stated that we would have as apartment owners. They basically said that these are the things that we would be able to have as part of our agreement, and they weren't unable to keep them throughout the entirety that we lived at the apartments. So complying with the tenancy code, it says the landlord is able to comply with the requirements of the applicable building and housing codes affecting health and safety, make all repairs or do whatever is necessary to put and keep the premises in a fit and habitable condition, keep the common areas, premises clean and a safe condition, and to be able to maintain appropriate receptacles, conveniences for removal of ashes, garbage, rubbish, or other waste from common point areas. This is Tennessee Code Statute 66-28-304. Unfortunately, during the year that we lived there, they had just not kept their word. In fact, we tried to make an agreement after they were unable to keep their word. We tried to make an agreement for a payment plan to be able to continue to live there until our lease was up at the end of the year, that December, or that January. And at the time they had agreed to it, they had given us the option. They had given us the option to be able to move our monthly rent fee from the 1st to the 22nd of every month with a late fee of $100. And before we could even get to the 22nd, they had unfortunately already sent a detainer summons to the court. I believe it was the 7th of October, before the 22nd, where they unfortunately sent in that detainer summons and had us and had asked the court to see about getting us removed from both the apartment and the premises and the lease. We had hoped they would keep their good faith and word, that we would be able to set up a payment plan. This was done on September 27th, after they had agreed to it and said that they would they would ask us to annotate it into their system based on the email submissions that we had between them. Again, this is between Haven Cross Creek, better known as Tripcap.
Mr. Corzo,
yes.
Sorry, let me, excuse me for interrupting, I want to ask a question about it. There was a hearing set originally, and both you and counsel for the other side showed up on it. And the trial court on its own, as I understand from the trial court's order, said, Mr. Corzo, you haven't responded yet. I'm not going to hear the motion now. We're going to reset it to a later date to give you an opportunity to respond. And the court, according to the court's order, set it for 8 a.m. on the morning of April 10. And again, according to the court's order, the court waited till the counsel for the other side was there. Excuse me, you were not there. The court waited till 8:30 to give you some additional time to see if you showed up, and didn't. And then the court went ahead and proceeded. And at that time, you weren't there. There was no filing by you. I mean, is that correct?
Unfortunately, no, Your Honor. And I'm not sure.
What's incorrect about that?
Well, I'm not sure if there was an issue with mailing or something, but every time we went to court, we were asked to come in at 9 a.m. We went there.
I'm sorry, but the court's order says that hearing in March, the court told you and counsel for the other side at that hearing that the April 10 hearing would be at 8 a.m.
We never received that.
But the court's order says that it told you that in person.
And that's what we came to dispute with them. Every time we went to court, they told us 9 a.m.
I understand that, but the court's order trial court's order says that at the March hearing, the trial court told you and counsel for the other side that I'm going to reschedule the hearing on this motion for summary judgment until April 10, and it will be at 8 a.m. Mm-hmm. And according to the court's order, the court told you that at that March hearing. Not that it was mailed to you, but that it actually told both sides at that hearing, when they were there, you were there, that it will be at 8 a.m.
Mm-hmm. Well, I understand that. That's totally understood. But it looks like here in the Courts of Appeal Tennessee at Knoxville, they were able to receive that there had not been a final judgment determined at the end at the case entered, and this was filed on May 9th, 2023. It seems that the court here had also not received word from the court in Chattanooga in Hamilton County that the final judgment had been received on April. It seems like I said, something happened within the dates that got messed up. That had I known it was 8 a.m., I would have been there, but they had told us 9 a.m. in court. All our previous court dates were 9 a.m., and they're all stated within the Circuit Court of Hamilton County. That, and to be honest, to be candidly, court in Hamilton County and Circuit Court for Judge Kyle Hedricks usually starts at 9 a.m. for particular cases like this. Had we been alerted either by paper or in court that it had been a different date, then we would have made it on that time and date. But when we arrived at court at 8:56, we tried to speak to Judge Kyle Hedricks, but the clerk had unfortunately stopped us and told us that we had missed our date and we wouldn't be unable to make it. We tried to plead our case with her to see and ask her. We were told 9 a.m. Of course, she didn't want to hear it. In fact, she was somewhat unprofessional when that happened because it seemed like we were all supposed to be there earlier, and I could understand that, but we were told 9 a.m. However, they allowed me to enter the courtroom at 8:56. I sat there for the first case at 9 a.m. Monica Guardado's attorney was there at 9 a.m. He was able to speak with the judge at that time. And even Judge Kyle Hendricks was able to allow me to approach the podium and state my case. But then again, he told me that, no, we told you 8 a.m. And I profusely said, this is not right, Judge. You told us 9 a.m. Like previous court cases that we've been here, we've always been coming at 9 a.m. However, he did not want to hear that, and he escorted me out, or the court escorted me out, which is why we brought this case to you guys, to the Court of Appeal in Tennessee, because I feel like I've been treated unfairly. as far as I can tell, Tripcap has used the best of their resources to make sure that our case not be heard. Even though that Circuit Court has already voluntarily dismissed the co-defendant Monica Guardado, which states here that it is dismissed without prejudice with the cost taxed to plaintiff, for which execution may issue if necessary. Yet I'm still being the one held responsible for this entire mess. I'm still being asked to pay the entirety of the debt that has been amounted living here, and all I want to ask is for restitution for this, because Tripcap has broken their lease, and based on them breaking their lease, responsibility does not fall on me.
Mr. Corzo, you've used your 15 minutes. Your time is up.
For sure.
Okay,
And,
thank you for...
And I want to thank the court, as well as Tennessee statute, because as far as I can understand, it looks like the law here could work for us, based on not wanting to amass this type of issue. And yeah, and if I'm able to be able to receive compensation for this, it's because the Tennessee Code statute allows me to be able to rightfully demand that whatever may have happened is
your time's
clear on
expired,
paper.
Mr. Corzo. Yeah, thank you for showing up this morning and making your argument.
Thank you.